Hello everyone, so welcome to our last lecture on NCA Constitutional Law course. So in this lecture number 10, we are going to cover our last three topics. 23rd topic, which is equality rights, then limitation of rights. When and where can government put few limitations, and those limitations has to be reasonable one. So this is the topic, this is the section that we have been discussing in almost all the topics. So here finally we will be discussing section 1, Oakes test, in detail under the topic of limitation of rights. Then last topic is remedies. So with this we will be completing our NCA Constitutional Law course, and in the last lecture I'll be taking up answer writing session. So firstly, let's look into syllabus. So equality rights, we have to go to section 15 and we have to look into Andrews versus Law Society of British Columbia and Fraser versus Canada, two important landmark cases. Then for limitation of rights, as I told you in the beginning, we have to go to section 1 and Oakes test, for which we have R versus Oakes, important landmark decision. Then last is remedies. For this we will be exploring two sections, section 24 and 52. 52 we already know that it talks about supremacy. Then for cases we have Vrain versus Alberta and Vancouver City versus Ward. So starting with equality right, whenever we see this topic, you have to keep one thing in mind, that for equality right under Canadian law, we have two sources. One is Canadian Bill of Rights, section 1B, that provides this equality, that protects equality. And second one is Canadian Charter of Rights and Freedom, section 15. Although the Bill of Rights, this now has become redundant, we don't follow this provision after we got in 1982 this full-fledged, detailed, separate provision for equality right under section 15. But still, we have to read this, we have to refer this, because firstly, under Canadian law before section 15, we had equality provision under Canadian Bill of Rights. So now let's read this provision. So section 1B of Canadian Bill of Rights says, which was enacted in 1960, provision for equality before law. So here, straightforward, one, equality was protected, equality before law. Also, its application was majorly limited to federal matter. So this section was an early recognition of importance of equality rights in Canadian jurisdiction, Canadian jurisprudence. That is why we read this. But now, since we have detailed, full-fledged provision under Canadian Charter of Rights and Freedom, section 15, so we go by this. In examination, you can in one line give reference to this section, but in detailed analysis, you have to only go for section 15. So Canadian Charter of Rights and Freedom, enacted as part of Constitution Act 1982, significantly expanded, strengthened, made equality rights in Canada more stronger, because here under section 1V we had only equality before law, but under section 15 we have few other equalities as well that are recognized by government. So charter guarantees under section 15 equality rights by ensuring that every individual, it means every human being, every person, is equal before law, under the law, has equal protection and benefit of law without discrimination. So you have to read these words, and because these and words are providing us four different kinds of equalities, four different kind of equality right. First one is that every person, individual, is equal before and under the law. Then you have equal protection. If you feel your equality right is being infringed by anyone, you can get equal protection with any other person. Then, without any discrimination based on various enumerated as well as analogous ground like race, national, ethnic origin, sex, age, mental, physical disability, you cannot be denied benefit of any kind of law based on these grounds. Nobody can tell you that being a woman, you are unequal to men. You cannot do this particular kind of job. So this is, we are talking about government things. Here we are not talking about private things. For that we have to go to their own codes, commissions, human rights code. Here we are only talking about the rights, equality rights, where government is involved. So government cannot deny you these kind of equalities. So it applies to both federal and provincial government, making a significant advancement in protection of equality rights in Canada. So Canadian Bill of Rights, as I told you, this has now become redundant. We don't follow this. Section 1B initially granted equality before law. Its application was limited to federal government. However, when we got Section 15, now we apply it to both levels of government, federal and provincial. So this Section 15 has expanded this protection. Significant legal case illustrating evolution of equality jurisprudence is R versus Drybone. In this case, court struck down a provision of Indian Act that criminalized intoxication for individual identified as Indian when off a reserve. So under this act, what the court did, court removed, struck down an important provision which was criminalizing intoxication for individuals who identified as Indian when they were off reserve. So here there was a discrimination with these indigenous people. So court deemed that this racial classification of individual is a violation of section 1B. This decision raised question about validity of various provisions of Indian Act, prompting subsequent challenges. However, inconsistency in defining applying section 1B led to disarray within legal interpretation. So here after this case, when more challenges came up, then court felt like there is a need to have a more detailed expanded equality right provision. So to address this ambiguity under section 1B, court developed a doctrine known as valid federal objective. Under this doctrine, if a law pursued with a valid federal objective, it was not considered breach of section 1B. However, court here did not provide clear guidance on what constitute a valid federal objective. So again, there were many discrepancies, there were many challenges. With the introduction of Section 15 of the Charter, Section 1B became irrelevant in terms of equality protection. Although it still remains in books, it still remains valid, but now Section 15 serves as primary constitutional provision which governs equality right, supplanting the limited scope of Section 1B. So the Section 1B's loopholes, ambiguities are now being supplanted by Section 15, fulfilled by Section 15. So firstly, let's read this. In examination, there are high chances that you can get a question on this, Section 15, more specifically on Section 15, subsection 2. So firstly, let's read this. Every individual means every human being is equal, number 1, before, number 2, under the law, number 3, has right to equal protection, can ask for this right to get protected before court of law, equal benefit of law, be it anywhere, any public job, employment, any public place. Nobody can discriminate you. In particular, what are the grounds of discrimination? So nobody can discriminate you on these listed grounds. So these are the grounds that are directly mentioned in the section. Number 1, race, nationality, ethnicity, color, religion, sex, age, mental or physical disability. So subsection 1. Section 1 does not preclude any law, program or activity that has its object the amelioration of condition. Amelioration means betterment, advancement. So subsection 2 says that there is an exception to this section 15(1). If any government is making any law, any program, any activity that is to make the situation better, that is to advance the condition of disadvantaged individual or group, including that are disadvantaged because of these grounds, no matter, like when we talk about nationality, ethnicity, indigenous people comes into picture. So if government is making something for indigenous people, there is some specific law, government is protecting them, then that does not mean that your equality right is being infringed. It's just that government is trying to give amelioration to those people, trying to put some efforts for the advancement of those people who are vulnerable, who are disadvantaged. So when I wrote constitutional law exam, I got a question related to subsection 2 only. So there was a question with regard to indigenous people, that their painting, their artistic rights were getting infringed, and government made a provision for that, that nobody can copy their work without asking them, without getting their permission. So there was a person, he said that my rights are getting infringed as I can make any kind of indigenous scenic painting. So, but the provisions were like, if you are making anything related to indigenous people, their culture, their tradition, then you have to firstly take permission from them. So here, the government was not depriving that person of their individual equality rights. Their government was just only protecting indigenous people from getting violated, as indigenous people live sometimes in remote areas, on reserve lands, so they don't know that particular person is using their work or copying their work or doing whatever with their artistic, their cultural, their traditional things in a good faith or in a bad faith. So that is why government is trying to protect their own rights. So here, if something any federal government, provincial government is making for the betterment, for the advancement, for particular protection of something related to indigenous people, that comes under section 15(2) clause. So here the equality right won't subsist, so that will get negated. So you have to understand these kind of things. Similarly, if any government is making any special provision for physically disabled, mentally disabled people, that they could have better opportunities, or they can get better, job opportunities or something like that, or there are some kind of reservations, so that is only for the advancement of those people, those disadvantaged people who are already at risk, who are already unequal based on these kind of listed ground. So this is the only intention behind this 15 subsection 2. So you have to keep this in mind because this is very, very important. Sometimes you get confused whether to apply subsection 2 or particular thing comes under the previously discussed charter rights. Like when I was writing exam, firstly I thought whether it should come under freedom of expression, because some kind of artistic thing, some kind of painting is a way of expression. But then when I thought about section 15 subsection 2, then it directly hit my mind that no, this thing is directly coming under subsection 2. This is a kind of program, kind of activity, kind of legislation that has been enacted by the government with the objective of advancing the condition of indigenous people. So questions like this might and do come in examination, so you have to be very careful. So again and again I am focusing on the provisions, word meanings, because if you are well versed with these provisions, then only you will be able to analyze at very first place that which rule, which section, which right is in the issue. Because if you are wrong at the very place, then the answer writing checker won't be going further with your analysis if your rule, your section is wrong. So this you will only get to know when you will be practicing answer writing, when you will be revising the chapters again and again. Only then it will give you better clarity in your mind. So equality includes the notion that every individual person is entitled to basic human dignity and respect. You have to treat everyone with basic respect and dignity. Equality before and under the law and equal protection benefit of law. So section 15 firstly applies to individual. As I told you, human beings, corporations, companies are not protected. Firstly, understand this. Then there are four kind of equalities that are discussed under section 15. Equality before law, under the law. So under the law requires that any infringement be by law. Discretionary decisions are unlikely to be captured by section 15. Equal protection of the law, equal benefit of the law. So there are 9 enumerated grounds, listed grounds on which nobody can discriminate you. So these are the mentioned ground that we already discussed in the previous provision. So if discrimination is one of the grounds above, it will be unconstitutional. But this list doesn't end here. There are few grounds which are not listed in section 15.1. Those are known as analogous ground. So analogous means parallel or similar. So similar kind of grounds, few of these come through various case laws and few of these are parallel or similar or comparable to the 9 grounds that are already mentioned under the section 15.1. So characteristics that are not readily changed or impossible to change, characteristics that are beyond your control. You cannot change those things like citizen status, sexual orientation, marital status. So based on these kind of analogous grounds, nobody can discriminate you, nobody can take away your equality right, because here you have no control. Being their nature, like citizenship status, sexual orientation, marital status, being analogous ground, being their very nature, they are such that you cannot change them. So the things that you have no control over, you have full right to get those things protected by the law. So grounds which are not analogous, on which you cannot ask for equality right, occupation, because here you have control. You can change if something comes up that okay, this is illegal or you cannot do that. Then substance orientation, like use of weed, intoxication, alcohol, any such thing. So these are not analogous ground. On these grounds, you cannot ask for section 15.1 protection. So now, as we already discussed, section 15.1 applies on individual. So definition of law in section 15. So firstly, you should understand that law means any legislation, statute, policy, regulation that has been enacted by the governments of Canada. Here, burden of proving that particular such and such legislation is not infringing any person's equality right is upon the government who has enacted such law. And this is as per section 32 that encompass all actions under taken under statutory authority. So the question is whether under section 15 we are only talking about laws. Are there any other government actions that they take beyond law that are not any legislation, that are discretionary exercises? Do they also come under section 15 protection? So answer is no, as per R versus SS 1990 case. But this viewpoint flawed, since it suggests that parliament is not making law, then in indirect way by delegating power to someone else can abridge equality right, but it cannot relegate a power it does not possess. So section 15 applies to same range of government action as other charter rights as defined in section 32. So here government cannot do something illegally, cannot do something behind someone else, like by assigning the work to any other authority. So whatever is directly enacted by, regulated by, be it a policy or anything by the government, and that particular thing is infringing upon your equality rights, then you definitely have protection. And this protection is as per section 32 read with section 15. So all government actions are under the same range. But here section 32 exclude private action from its application. So section 15 does not apply to private acts of discrimination, as I told you in the beginning as well. For that we have human right codes. So human right code only influence the private actions as seen in cases like Blaney versus Ontario Hockey Association. Then there are four kinds of equalities under section 15. So when we categorize this, first we have absolute equality. Absolute equality does not mean that you have to treat everyone equal. It means treat equal as equal, alike as alike. As I told you, you cannot treat a stable person, a healthy person with a physically disabled person. So that is not equality. So law treat every individual differently based on what they need, based on their requirement, their factors. So Aristotle's definition of justice implies treating alike individuals who are alike. As I told you, treating same as same, differently those who are not, but it's criticized for its high level of generality, but still we follow this definition. As section 15 equality also means treating equal as equal. Then, before Andrew's case, courts applied the similarly situated test which compared the treatment of individuals under the law. Andrews deemed this test deficient, signaling the need for a new approach. So now we have formal and substantive equality concept as well. Formal equality based on similarly situated test overlooks indirect discrimination. So formal equality just only straightaway says that all individuals are subject to same laws and standards without regard to their personal characteristics, circumstances. So here we are not talking about the other contextual factors that are related to a particular person. We are only saying that okay, equality means everyone is equal, equal treatment under law. But when we talk about substantive equality, it necessitates considering other factors related to race, sex, disability. So it goes beyond mere formal equality. It considers actual outcomes, impact of laws and policies. So focus is on achieving equitable outcome. So here we acknowledge and accommodate differences. We target the people, their situations for disadvantaged or vulnerable categories. So here we remove kind of systematic discrimination, structural barriers. So substantive equality more effectively address real world disparities and injustice rather than going for formal equality. So reasonable classification test used in US justifies unequal treatment if it serves as a legitimate state purpose and employ reasonable classification. Before the Charter, courts deferred to Parliament's judgment on laws pursuing valid federal objective, that if particular legislation has valid federal objective, then it won't be protected under any kind of equality right. However, Charter intended a different approach. It distinguished its meaning related to equality rights, its scope from. So initially what happened, Section 15 cases flooded the courts, but there were many issues that came before the court that courts felt like, okay, these do constitute some kind of discrimination, these do come under the protection of Section 15, but the grounds are not those which are mentioned under Section 15. So there was a need to go beyond the list of 9 grounds and to add on analogous grounds. So initially Section 15 cases flooded the courts, but distinctions were upheld. Andrew versus Law Society of BC established Section 15 prohibits discrimination based on listed or analogous grounds. So here with listed, analogous grounds also got added. So discrimination, we all know that nobody can discriminate on the 9 grounds, but now we have after Andrews few other additional grounds as well. So those characteristics which goes beyond individual control like citizenship, sexual orientation and few other analogous grounds. So those are also the ones which calls for equality rights. So firstly, let's look into this landmark case of Andrew versus Law Society of BC 1989. Andrew was a British citizen, permanent resident of Canada, met all requirements for admission to British Columbia Bar except one requirement, Canadian citizenship. So he had permanent residency, only he didn't have Canadian citizenship. So he applied under Section 15(1) Charter which guarantees equality right. His application was dismissed. However, his appeal was allowed. So issue was whether Canadian citizenship requirement for admission to British Columbia Bar infringed denied equality rights granted by Section 15. If so, whether this infringement justified by Section 1 of the Charter. So citizenship requirement did infringe Section 15 and it was not justified under Section 1. So what was the reasoning behind this? So firstly, discrimination based on those grounds on which a person has no control is prohibited by Section 15. So, discrimination involves distinction based on personal characteristics that impose disadvantages or withhold advantages. Discrimination based on personal characteristics attributed solely on the basis of association with a group is rarely justified. So, here the person had full-fledged legal knowledge, expertise, educational requirements that were meant to required for him to be part of Canadian Law Society, bar. So only thing was he didn't have citizenship. So being associated with a particular kind of group is rarely justified. So charter required two-step approach here. Firstly, determine if there was an infringement. Secondly, if that infringement is justified under section 1. So grounds enumerated under section 15(1) are not exhaustive. We know that analogous grounds are also covered. Impugned distinction must go beyond a mere finding of distinction. Burden of proof rests on citizen to establish the infringement of the charter right. State must justify the infringement. Citizenship is typically not within an individual's control. It is a characteristic of personhood. Non-citizens are relatively politically powerless and may suffer from legislative decision. So this is something that goes beyond a person's control. There are few legislative requirements. So if a person is non-citizen, that person is considered as powerless, vulnerable, disadvantaged than other people who are citizens of Canada. So that is why there is a need to have a little liberal approach to solve this issue. So legislative conditioning on basis of citizenship may undermine the value of free and democratic society. Legislation failed to meet proportionality test of section 1. Citizenship did not ensure familiarity with Canadian institutions. As I told you, he had full-fledged expertise to become a lawyer in Canada. Restriction of access to legal profession based on citizenship. This was over-inclusive. Less drastic methods were available over broad law. While certain state activity may be confined to full member of political society, such restrictions should not apply to legal profession as a whole. This dissenting opinion argued that citizenship requirement was reasonable, sustainable given the importance of legal profession in government, but this dissenting view didn't stand here as the majority said that citizenship is an analogous ground and based on that a person has full right to have his or her equality rights protected. So citizenship requirement for admission of bar was found to infringe section 15, not justified. So there were two important steps that we call as Andrews test, and this Andrews test we apply whenever section 15 is in any question. So does the law make a distinction based on enumerated analogous ground? Impact of any law, what is important? Intention of government is irrelevant. Here you are not going towards the intention of government with which objective the legislation has been made. You have to see whether there is a discrimination based on either listed ground or on analogous ground. So if the case comes under one of the grounds, either enumerated or analogous, discrimination established by showing the distinction created disadvantage by perpetuating prejudice stereotype. Once this step is proven, then you can go to section 1. 1, it is clearly defined that okay, there is a discrimination and that is definitely infringing a person's equality right. Then you can at last check whether there is any reasonable limit, whether we can protect this particular law under section 1 or not. So burden of proving the infringement lies on the claimant, burden of justifying their step, their law. So you have to look into here that there is a difference in burden of proving. So burden of proving equality right, it is upon the claimant, and burden of proving that there is no infringement is on the government. So applying the test in Andrews, the court said there was a law that created a distinction, clear distinction created by provision that resulted in a distinction between citizen and non-citizen. Distinction was based on enumerated analogous ground. You cannot choose your own citizenship. Step 1 satisfied here. The court said discrimination was based by denying admission to non-citizen. You are discriminating someone. So you are taking away some kind of public right. The distinction imposed a disadvantage purely as a result of a prejudice. So Andrew was able to demonstrate the infringement. So Section 1 analysis court said that there was a pressing substantial objective to ensure lawyers who practice law are properly qualified. So there is no question of qualified with regard to Andrew. He fulfills all the educational requirements. So rational connection, the court did not find a rational connection to being a citizen to being properly qualified. So court said that in order to be qualified as a lawyer, being a citizen has no rational connection. It doesn't make sense at any step. So that is why section 1 analysis didn't stand here. So this was the detailed case. So again, I am saying that in examination, if you're getting a question section 15, you have to go by the steps that are being followed in Andrews test. So then there was one concept of human dignity that wasn't talked about in Andrews. So breach of section 15 occurred whenever a disadvantage was imposed based on listed or analogous ground. This fully engaged section 15 while consideration of reasonableness or fairness fell under section 1. This demarcated distinction between section 15 and 1. So the dissenting judge who had different viewpoint in this Andrews case said that more than proposing more than just listed or analogous ground were necessary. Over time, the courts diverged into three camps regarding Section 15 interpretation. A division ultimately settled in Law versus Canada 1999 case. So here, Supreme Court of Canada introduced a new interpretation of Section 15. They said that rather than just focusing on discrimination, there is a concept of human dignity also that should bring into picture. So departing from earlier competing interpretation, this freshly perspective outlined three key aspects. So section 15 applied solely to legislative distinction based on these grounds. What about a discrimination that is affecting, that is impairing human dignity? So discrimination under section 15 necessitated additional element which is not in listed grounds with neither in analogous ground. So that is breach of human dignity. What about breach of human dignity? How you are going to cover that under section 15? So this demanded a new requirement. So for instance, under federal CPP rules, a surviving spouse under section 15 could not collect survivor benefit. In Andrews, this would have constituted discrimination under section 15, triggering scrutiny under section 1 to justify age-based distinction as per standard set in O. With the inclusion of new criteria of human dignity in section 15, burden to prove this aspect fell on the claimant, leading to claim denial without recourse to section 1. Though human dignity remained undefined by equivocal justice, four contextual factors were provided. Presence of pre-existing disadvantage, stereotype, prejudice, vulnerability. So the court said that if you have to look into impairment of human dignity, if you want to bring this concept into picture, in addition to listed or analogous ground, you want to see whether there is a human dignity impairment or not, then there are four factors that you have to keep in mind. Number one, whether particular distinction, whether particular disadvantage, stereotype, prejudice, vulnerability was already existing. Then you have to align between the distinction, disadvantage and claimant circumstances. Does the claimant circumstances, current circumstances fit under those kind of discrimination? Thirdly, you have to see whether the law has been made for the betterment of some kind of disadvantaged people. So whether there is presence of ameliorative purposes or effects on other groups. So you have to see protecting one person shouldn't be providing any kind of discrimination, any kind of harm, disadvantage, so some other group. So there has to be equality for everyone. There has to be balance between the interest. Then you have to look into nature of. So we have another case of R versus CAP. So the previous confusions regarding whether to bring human dignity into picture into one of the grounds for discrimination or not. So this case ended this controversy. R versus CAP 2008. marked a departure from previous jurisprudence requiring retracting the requirement of human dignity impairment, replacing it with a similar criteria of discrimination. However, uncertainty persists regarding any differences between two concepts, with scholars like Hogg questioning the distinction. So, like Peter Hoggs, he said that why are we even questioning this distinction? Isn't it that human dignity impairment itself comes under any kind of discrimination grounds? Those are already mentioned under Section 15. So, this historical ambiguity confusion surrounding human dignity led to challenges in its application, often causing disagreement between Supreme Court of Canada and lower court. So finally, it was concluded that whatever Section 15 is providing us, whatever ground Section 15 is providing us, they are more than enough. They are in itself imbibing the human dignity impairment concept, and also for fairness, we have Section 1 also. So you can go to Section 1 rather than doing any such unnecessarily expansion of Section 15. So this was what was concluded after R versus Cap. Factor of correspondence. This factor, articulated by Abakuchi, emerged as pivotal in assessing human dignity impairment. Even if other factors pointed elsewhere, the evaluation of correspondence frequently determined outcome. It entailed a court assessment of legitimacy of statutory purpose, reasonableness of employing listed analogous ground to achieve this purpose. If accurate, this factor largely usurped Section 1's role. So they say that this factor of correspondence also has to be bring into mind, because Section 1's role is to see that everyone is treated equal. The court will justify their reasonable limits put on equality rights. The court will make sure that everyone under Section 1 gets to know that why particular government has taken such and such step. The court, the judges, the government will, through Section 1, make sure that everyone gets to know that there is fairness in their particular enactment of law. So when we are talking about fairness, then human dignity concept automatically comes into that. So here, by talking about human dignity concept separately, we are in a way usurping the role of Section 1. So Section 1 is there to protect people in a free and democratic society. So this is what is the main objective of Section 1. So any reasonable limit is justified if it is justified for a free and democratic society for the people living there. That means you are protecting the dignity of people of your nation. So any such step, if it is justified by Section 1, then there is no need to take this human dignity impairment concept separately. So finally, as I told you earlier, R versus Cap ended this controversy and said that discrimination without human dignity is good to go for this legal test analysis of Section 15. So Supreme Court of Canada acknowledged the legal test confusion and its additional burden on equality claimant. So Supreme Court says there is no need to put something extra than listed or analogous grounds. So this could be additional burden on equality claimants if they have to prove before the court of law one more thing. So consequently, it eliminated the requirement human dignity impairment from Section 15. Hogg advocated viewing discrimination to Section 15 merely as a disadvantage imposed on these grounds, delegating reasonableness, justification assessment to Section 1. This is more than enough. Then there is a concept of group disadvantage. In Andrew's case, all three opinions in court implied that disadvantaged powerlessness was characteristic of groups protected by Section 15. However, how can a court determine whether a group is still disadvantaged when societal status are evolving? So here all that is need to be established is whether a particular statute imposed a burden or deny benefit solely based on these kind of listed ground. Then in Law versus Canada, it was stated that a claimant's association with a disadvantaged group or groups was not per se determinative of an impairment of human dignity. So if you are saying that a particular person comes from some indigenous category, that does not mean that all indigenous people face equality right issue. So it is a person to person thing. So this seems to reflect the current stance of the court. It is not necessary for the claimant to prove membership in a disadvantaged group. Person can ask for his right to be claimed on personal basis, on individual basis. So person has to just demonstrate specific disadvantage due to legal distinction, that would be sufficient. So then we have direct and indirect discriminations. Under this, we call for substantive equality. As I told you earlier, the meaning that this goes beyond formal equality. So a law may be discriminatory on its face. This is direct discrimination covered by section 15. But sometimes a law is discriminatory in its effect also. This is indirect discrimination without expressly employing the categories listed in section 15 or even the analogous one. So the term substantive equality protects both direct as well as indirect discrimination. So section 15 talks about substantive equality also. Section 15 does not only provide formal equality, section 15 goes beyond that. So section 50 application case to case basis provides protection for indirect discrimination also. So unintended discrimination. Because intention is not a factor in discrimination under section 15, judgment about whether indirect discrimination is intended, whether there was intention behind particular such law and law, that is unnecessary. If the government has enacted a law, then court will not look into the intention. The government cannot say we were not intending to make anything discriminatory for such and such person. If there is a law that is breaching equality rights, no matter whatever the intention behind that law was, that person whose rights are being infringed by such legislation can go to court for the protection of rights. Then reasonable accommodation. Concept of reasonable accommodation established under Human Rights Code applies under section 15, requiring accommodation for cases of indirect and unintended discrimination. Like for religious observation, for disability, there are cases that ask for reasonable accommodation. Like for disabled people, as I told you, that you cannot here ask for similar kind of accommodation if you are a healthy person to that of a disabled person. They might need a reasonable, proper, different kind of accommodation, and this is justified equality right. Then justification under section 1. Section 1 applies to section 15 no differently than to laws infringing other right. Since law introduced human dignity into section 15, only one section 15 case has been saved by section 1. In most cases, whenever section 1 comes into picture, because equality rights encompass in themselves so many other things. So there was only till date one case where such and such enactment that was made by government and that was affecting equality rights was being justified protected by section 1. Otherwise, usually there is no room for section 1 when section 15 is in question. So when the court employs correspondence factor to decide human dignity issue, it considers the legitimacy of law's purpose, reasonableness. This inquiry resembles to loose form of justification under section 1. Court's retraction in R versus Cap is unlikely to restore section 1 to its intended justificatory role because substituted concept of discrimination is almost similar to human dignity. So although we are not straight away talking about human dignity when we are talking about section 15, but in an indirect form automatically human dignity is in question when your equality rights are being infringed. So that is why it's very rare that when government is doing something that is infringing your equality rights, that action could be protected under section 1. So these are the grounds, you can read these ones. Age, ground of discrimination, these are permitted by constitution. So allowed by section 23, 29, 99, where these are allowed? These are allowed for being discrimination only when it relates to certain appointments. Otherwise, basis on age, you cannot discriminate anyone. Then race allowed by section 91, 24 confers on federal parliament to make laws for Indians and other indigenous people. So section 91(24) discrimination is allowed, which is protected under section 15 subsection 2 because the purpose is ameliorative. Then religion section 93, which permits Catholic school funding, which has been criticized but upheld by Supreme Court of Canada. Again 15 subsection 2 protect this. Then citizenship allowed by section 6. Section 6(1) contemplate a difference in treatment between citizen and non-citizen. While the right to remain inside Canada cannot be challenged by section 15, laws that impose disabilities on non-citizen have been held to be discriminatory under section 15 as seen in Andrew case. So there are few things like right to vote, those are protected by section 6(1), but any law that is imposing some kind of disability, some kind of disadvantage on non-citizen, that is not justified, and we already saw this in Andrew's case. Then language. Few language rights are also protected under section 16 to 23 of Charter, which create other qualification of section 15 like English and French only have special status, right to minority language education only apply to English and French. So these are not protected ones. Now, what are the prohibited grounds? So on the basis of race, nobody can discriminate, expressly prohibited. However, if there is any affirmative action, as I told you, related to indigenous people, then that falls under section 15(2), that is justified. Then religion prohibited. You cannot do discrimination except section 93, where government is allowing funding for Catholic school. Marital status, this is analogous ground. Important. This came before the courts in Miron versus Trudell case. So discrimination based on marital status is subject to equality review. Sexual orientation analogous ground. Sexual orientation not expressly prohibited under section 15, but this is analogous ground. Any kind of such discrimination is unconstitutional, cannot be saved by section 1 as held in Egan versus Canada, Brent versus Alberta case. Then basis on sex prohibited, age again prohibited here. Mental or physical disability prohibited, citizenship analogous, we saw this in Andrew's case. Then place of residence not analogous. This lacks the immutability common to listed grounds required for analogous ground, because here it's not something that is not in your control. Place of residence is under your control, you can change that. So this is not analogous ground, no protection. Occupation again not. So section 15(2) affirmative action program. So as we discussed in the very beginning, section 15(2) ensures that section 15(1) cannot be used to prevent implementation of any affirmative positive action program. Court has said that section 15(2) is not an exception to section 15(1). Rather, these both should be read together to ensure that there is a coherence, there is a cooperation between these two sections. So in R versus Cap 2008 case, federal government set up a program that was designed to enhance Aboriginal involvement in commercial fishing. Significant part of this was introduction of three sale program, one of which resulted in issuance of communal fishing license to 3 Aboriginal bands. Appellants who were non-Aboriginal fishers participated in a protest fishery and were charged with fishing at a prohibited time. So they argued that the communal license discriminated against them on the basis of race. Trial judge found that license granted to bands breached appellants' equality right, and it was not justified. The Crown argued that there was no discrimination because this was a part of ameliorative program under section 15(2) that was designed to ameliorate for the betterment of any disadvantaged group. So to establish section 15(2), two-part test was evolved in R versus Cap. So this is very important. Firstly, you have to see, is there a law, program or activity? All that needs to be shown is that government implemented such law, program or activity. Number two, whether the objective is the amelioration of condition of some disadvantaged individual or group. You must consider whether the government has chosen a rational means of achieving their ameliorative purpose. Ameliorative purpose does not need to be the sole purpose of the legislation, it has to be one of the purpose. However, importance of these purposes within legislative scheme may determine the scope of section 15(2) protection. Once it is established that the purpose of such law program or activity was ameliorative, the next step is to look whether the purpose is directed at improving the position of disadvantaged group. Disadvantage mean vulnerability, prejudice, negative social characterization. So we have few other cases that are mentioned in notes. You can go through those cases, but for this the important one is R versus CAP. Then the one that is mentioned in syllabus directly, Fraser versus Canada. This is again latest judgment and very important to cover. So in this case, there were three retired members of RCMP who took maternity leave. When they returned to work, they found it difficult to manage both work and childcare responsibility. At this time, RCMP did not allow part-time work. RCMP started a job sharing program where members could split the duties and responsibilities of one full-time position. These three claimants entered into this program expecting it would still make them eligible for full pension credit. They were later informed that they would not be eligible for full pension credit for their job sharing. Supreme Court stated to prove a prima facie violation of Section 15(1), claimant must show that the particular law state action in how it is written or its actual impact creates a difference based on numerated or analogous ground, and it is imposing or denies or burdening benefits that make the disadvantage worse. So claimants claim that their ineligibility for full pension credit infringe their Section 15 rights as it mainly affect women because women were the ones who took maternity leave. Majority of Supreme Court highlighted that there must be more awareness of adverse impact discrimination. Government must be more aware of such kind of policy. So Andrews test was being followed. Mainly women enrolled in this program disadvantaged when it came to balancing professional work and childcare. Majority held that inability of them to receive pension credit further worsened their inequality, deteriorated their situation, burdened. It was not fair to the women in those programs. So this was held that here equality rights of women were infringed. So now we are done with equality rights. Next is limitation of rights. So this is the section that we have been referring till here. So section 1 of the Constitution Act of 1982 outlines that whatever Canadian Charter of Rights and Freedom are there, which provides rights and freedom, they are not absolute. Government can put reasonable limits as per law. So those reasonable limits should be demonstrably justified in a free and democratic society. Here we are not talking about any kind of autocratic government, any kind of monopolistic thing that they are putting upon their people some illegal things. So this is something that is legal prescribed by law and government has full-fledged right. So whenever any fundamental right, any charter right is in question, at last what we do, we check whether the infringement is saved by section 1. So section 1 is a saving clause, is a saving provision, and it saves justified the actions, the legislation that government has made. So this section introduces a two-stage judicial review process. Firstly, the courts will determine if a law restricts charter right. Whenever some law is in question, its violation, infringement is in question, the court's job is firstly to see if actually some law is interfering with some charter right. Secondly, they will see whether that interference is justified by section 1. So considering values like human dignity, social justice, equality, respect for cultural diversity, if government has done something to protect all these, then that interference is justified. Section 1 reflects European influence. It differs from US Bill of Rights, which lack explicit limitation clause. Here we have explicit limitation. Section 1 is not only mechanism for limiting right. We have section 33 also override clause which can also be used, and this we have already discussed earlier. So what is the concept behind section 1? So as per legal scholar Dworkin is that rights should only be limited when benefits to other outweigh the cost to the right holder. So for example, You are one individual, your right is in question, but if government is doing something justifiable, something reasonable, which is for the upliftment, which is for the benefit of thousand other people, then their government's action could be saved by section 1. But again, here we are not saying that one person's rights does not matter if thousand persons' rights are also in question. Here we are saying only justified thing. If that thing is as per law, that thing is reasonable, constitutional, only then section 1 saves government action. So in practice, section 1 serve two functions: provide limits on granted right, also expressly guaranteeing the rights and freedom in the charter, because if something is not saved by section 1, then your rights are guaranteed. Nobody can take away that thing from you. Relationship between section 1 and rights. So when we talk about charter rights, firstly, we have to go by the interpretation and justification. So if courts broadly interpret a right beyond its intended purpose, they are likely to lower the standard of justification under section 1 to impose limits on that right. So Peter Hogg argues that high standards set by Oakes test require careful definition of granted rights to prevent them from being interpreted too broadly. The interpretation when we are relating section 1 with rights should not be too broad. Then upon whom there is burden of proof. So burden of proof is with the individual who is asserting the charter breach. But in the second stage, when we are talking about Oakes test, when we are talking about section 1, then it's the government's burden to justify that their law comes under section 1. Presumption of constitutionality. When a statute is challenged on federal ground, there is a presumption that it is constitutional. Nothing is invalid, nothing is illegal. So it leads to three consequences: that courts exercise restraint in judicial review, striking down laws only if they are clearly offended. So courts can take away, take out laws that are clearly offensive, that are clearly violating some kind of charter right. If the law's validity depends upon factual finding, then there has to be a rational basis for that finding. And if there are two interpretations to any law, the constitutional one, which is in consonance with the constitutional provisions, that we will follow. So this is also known as reading down, that we already discussed earlier, one of the remedy. So what are the limits on rights? So not all infringements are limits. Not every infringement count as a limit under section 1. Like for example, Quebec School Board case, a clause in Quebec's language charter limited admission to English school to children whose parents had attended English schools in Quebec, conflicting with section 23(1)(b) of charter, which guarantees admission based on parents' attendance at English schools anywhere in Canada. So the Supreme Court of Canada here refused to justify this under section 1. Then we are talking about that justify any kind of thing, reasonable limit prescribed by law. So what do we mean by reasonable limit prescribed by law? So section 1 stipulates that charter rights are subject to reasonable limit prescribed by law. So it means an act that is not legal can never be justified under section 1. An act that is in itself illegal, it does not require section 1's test. The phrase prescribed by law underscored values fundamental to constitutionalism and rule of law. So as per this processes of fairness, we will be putting reasonable limits. A law conferring discretion on a board or official to act in derogation of charter right meets the prescribed by law requirement if that discretion is constrained by legal standard. Again, anything that is considered as an intelligible standard, that is prescribed by law. In Canada, a law may be void for vagueness if it fails to meet requirement that a limit on charter right is prescribed by law. So requirement of an intelligible standard is intended to capture the values protected by prescribed by law, though it is itself somewhat vague. However, this requirement is not overly demanding. So all official actions, all government actions must be authorized by law if you want something to be prescribed by law. citizens must have a reasonable opportunity. As I told you, all the procedural fairness things have to be followed. Reasonable and demonstrably justified. So the requirement of reasonable and demonstrable justification are cumulative rather than alternative. These both go simultaneously. Courts have not attempted to distinguish these two requirements. Instead, they said that this is one unique, unified, together, blended standard for them. So both things have to be justified. So now main important thing, when you are performing Oakes test. So in R versus Oakes case in itself, four important criteria came up. The court says that if you want something to be reasonable and demonstrably justified in a free and democratic society, it has to pass these four criteria. So sufficiently important objective. Firstly, the legislation that is in question, the law, its objective should be sufficiently important to justify the limitation on charter right. There must be a rational connection to achieve the objective. The damage, the impairment on the right should be as little as possible. The law must not have effects that are disproportionately severe on people. So as I told you, you have to check the proportionality, the effect, to what extent someone is getting impaired or someone has been disproportionately affected by that government action. So the third criteria, that is minimal impairment, is the main focal point of inquiry into section 1. So now we're going to take up all these four criteria one by one. First criteria is sufficiently important objective. So you have to see, determine the objective, the aim, the purpose of the legislation. Only laws with objectives that are sufficiently important can justify this limit of charter right. So now the question is, what is sufficiently important? So Oakes test provide guidance on this. Firstly, the legislative objective must align with values that are implied in a free and democratic society, as we discussed earlier, like human dignity, peace, all those things. Then the objective must address some pressing important concern that is not a minute, trivial, small one. It should be something very important for our whole nation. Objective should aim for the realization of collective goals of fundamental importance. Then case analysis. Quebec School Board case, the court characterized a severe infringement of the charter as a denial right than a limit of the right, refusing arguments based on Quebec's distinct society. Then we have Attorney General of Quebec versus Ford. Law requiring ads in French only was not struck down due to doubt about the legitimacy of the purpose, but because banning of English disproportionately impaired the right of English speaker. So here the court says that the objective, the purpose was doubtful. Then inadmissible objective. The court has only once rejected a legislative objective in R versus Big M Dart case, Drug Mart case. Lord's Day Act was found to infringe on freedom of religion because its purpose. So see here, court straight away looked into the purpose was to compel observance of Christian Sabbath, which was contradicting the charter right. Three rules emerge from this case. Objective cannot justify a limit of section 1 if it is incompatible with charter value. It cannot be justified if it is ultra wide, beyond the power of legislative body. There must be consistency in legislative objective, avoiding shifting objective over time. So then second criteria is rational connection. So this step is reached only after first step has been taken. Firstly, you have to see the objective, then proportionality. First element of proportionality described in Oakes. So Supreme Court of Canada found that the law failed the rational connection requirement in this particular case. Validity of a provision in Federal Narcotic Control Act which presumed possession for the purpose of trafficking based on mere possession of drugs. So protect society from drug trafficking deemed sufficiently important to justify under section 1, but it failed the second stage. No rational connection between possession and presumption of trafficking was made. So then causation, the essence of test is a causal relationship between objective and what are the consequences, what are the causes that the measures enacted by the law. So connection based on reason, logic would be sufficient if even if evidence is inconclusive as held in McDonald versus Canada. So there has to be a particular logical reason behind the objective with which this particular law has made. Then third is least drastic mean. So third Oakes test criteria, minimum impairment. The law should pursue the objective by least drastic mean, should not impair someone. This is the heart and soul of Section 1 justification. Numerous laws have failed this step, like Criminal Code's felony murder rule being too drastic to discharge weapon use, Quebec's prohibition of English in commercial sign being too drastic to protect French language. So there is almost always a less drastic mean of achieving something. So go for that. Then vulnerable groups, laws designed to protect vulnerable groups, these are important. These are considerations for deference. Then laws premised on complex social science evidence, then dealing with complex social issues like smoking, reconciling the interest of competing groups, allocating scarce resources. So here you might see that few people will think that government has taken drastic step, but no, these steps are for particular kind of differences that are important. Last is fourth is proportionate effect. So third element of proportionality requires between the effect of measure responsible for limiting the charter right or freedom and the objective identified are of sufficient importance. So rational collection and least drastic means, the means of the law have already been judged to be rationally connected to the objective and to be the least drastic mean of accomplishing the objective, now requires a balance. So there has to be a balance, a proportionality between the objective sought by the law against the infringement of the charter. So Peter Hogg criticized this thing. Hogg argues this step has never influenced the outcome of any release of any case. It is just a restatement. It is just a repetitive thing of the first one. If first three steps are passed, law cannot be judged to swear. Otherwise, it would be sufficiently important to justify limiting a charter right. So Hawke's position, a positive answer to step 1 will always lead to an positive answer to this step. So this is what Peter Hawke say, that if the first step, the objective one is passed, then the proportionate effect will also pass. Then how section 1 applies to equality right. So this we already discussed under Andrews versus Law Society of BC. Then it applies to few qualified right also. So qualified rights section 1 justify infringement of charter right that are qualified by notion of reasonableness or regularity. So answer is yes, it applies to qualified right. Then does it apply to section 7? So the guarantee not to be deprived of life, liberty, security except in accordance with principle of fundamental justice. Section 1 limit has been upheld in minority opinion but never by majority. This I told you when we discussed this topic as well, that life, liberty, security, there are rare chances that some action to take someone's life, liberty, security by government would be justified. Then section 8, the right to be secure against unreasonable search and seizure. So while unreasonable searches are typically not justified, it is theoretically possible for a law to fail section 8 test but pass the broader section 1 test of reasonableness. Then section 9, the right not to be arbitrarily detained, imprisonment, definitely justified if it is passed by section 1 as held in R versus Hupsky. Then it applies to section 11 as well, right to be informed without unreasonable delay, then right to be tried within reasonable time. So similar to section 8, theoretically fails section 11 test, but something can be passed by section 1 test. Then section 12, the right not to be subject to cruel, unusual treatment or punishment. This right is considered absolute and cannot be justified. So upon this section, this is Hogg's belief, does not apply. Then Oakes test applies to common law limits on right. There are few challenges, there are few differences. If a statute offends a charter right and is not justified, it is struck down. However, a common law rule can be amended by the court itself. So here, if something is against the common law, we are not taking away that thing. We can only amend that thing. Then on emergency measure. So there is no specific provision in charter for emergency measure. It is up to the court to decide if restrictions are reasonable, demonstrably justified in a free and democratic society during emergency. So in R versus Oak 1986, Supreme Court of Canada examined whether Section 8 of Narcotic Control Act, which imposed reverse burden on the accused, was a reasonable, demonstrably justified limit on right under Section 1. The court had to determine if the reverse onus violated Section 11D of the Charter, which guarantees presumption of innocence until proven guilty. So Section 11D of Charter was in question, Section 8 of Narcotic Control Act. So key points from paragraph 62 to 79. Canadian Charter of Rights and Freedom guarantees right and freedom subject only to reasonable limits. Section 1 serves two purposes, as I told you in the beginning as well. Guarantees the right, provide the criteria for justifying limits on those rights. So any limit on rights must be reasonably demonstrably justified. We all know that burden of proof is lying on the party seeking to uphold the limitation. Usually it's on the government when it comes to Oakes test. Then we have to perform different tests that we already discussed. So proportionality test, then there are different things that comes under in. Then application to case. So Section 8 of Narcotic Control Act aimed to curb drug trafficking by facilitating the conviction of drug traffickers. Court recognized this objective as substantially and pressing given the seriousness of drug trafficking. Then when it came to rational connection, then here at this step, the court found that presumption of intent to traffic based only on possession, especially very small quantity, that if someone is having possessing drugs, does not mean you can assume on your own that that person will be going into drug trafficking thing. So that there was no rational connection, it was illogical, irrational, unfair result. Given the serious consequences of the offense, including potential life imprisonment, lack of rational connection failed to satisfy first component of proportionality test. Because the first component was not satisfied, the court did not need to consider the other two components like the minimal impairment, proportionality, because the very objective and the rational connection, these things lack. So what was concluded? So court concluded that Section 8 of Narcotic Control Act did not meet the requirement of Section 1. Onus provision was not reasonable, demonstrably justified limit. So this decision is very, very important. It underscores the stringent standard required for justifying limit. Whenever we are talking about go to Oakes test, so Oakes test means you have to follow all these steps. You have to check this standard and the importance of rational, fair legislative measure in a free and democratic society. So now comes our last topic, remedy. So if someone's right is being infringed, how court is going to provide remedy to that person. So section 24 is the main section, but we are going to read section 52 as well here. Firstly, section 24. Anyone whose rights or freedoms as granted by this charter have been infringed, denied, may apply to a court of competent jurisdiction to obtain such remedy as the court consider appropriate. So this is direct remedy section, that if someone's charter rights are being infringed. So here we are talking about only the charter rights. So remember, if you have to enforce your granted rights and freedom, you have to go to section 24. But we have section 52 as well, which protects whole of constitution. So it says Constitution of Canada is the supreme law of Canada, and any law inconsistent with provision of the Constitution to the extent of inconsistency is of no force. Corporations cannot claim these remedies. Here we are only talking about individuals. So section 52 you have to bring into picture if something is just not related to charter rights, if something is from Constitution generally, because this is the main supremacy clause. But if you are only talking about your charter right, then you have to go to section 24. So section 24, enforcement of granted rights and freedom. So this we already read. Exclusion of evidence bringing administration justice into disrepute, where in proceeding under subsection 1, a court concludes that evidence was obtained in a manner that infringed, denied any rights or freedom granted by charter. So evidence shall be included. So this is also as per section 24 clause 2. So here inadmissible evidences comes into picture. So section 24(1) only applies to remedies in response to breach of the charter right. If you have to go to entire constitution, including charter, including everything, then you have to go to section 52. Any law that is inconsistent with any part of the constitution can struck down under section 52, but to seek remedy under section 24(1), there must be violation of a charter right. So this is important. So remedies can only be awarded by a court of competent jurisdiction, which includes the Superior Court. Section 96 talks about this. There are three primary factors that the court will consider when awarding remedies. So firstly, ensuring that with the particular remedy that they are assigning, the wrong should be cured. Ensuring that the government is compliant in the future, should learn from their mistake, avoiding unnecessarily interference with government power. So what are the available remedies? So we have declaration, we can interfere in the legislation, we can struck down whatever we feel like, then we can award damages, cause supervisory orders, order by court, where the court supervise the party, often require the party to follow up with court to show progress. Then we have another range of remedies like damages and cost was awarded in Vancouver versus Ward. Section 52(1), the court can strike down, read down legislation in Brand versus Alberta like happened. So provisions can be read or struck down, remedy that is available under section 52(1), but under 24 we have only personal remedies. So whenever on examination you have to see if remedy is striking down the provision, striking down, negating any law, legislation, taking out any provision, then you have to go to section 52. But if you are awarding any damages, some kind of right is violated where legislation is constitutional, the legislation in itself is not unconstitutional, then you have to go by section 24(1). So if unconstitutional, struck down, follow section 52(1) in your exam. If constitutional, just your right is violated, then follow section 24. So you cannot make any provision, any statute, and you cannot exempt any statute from constitution, that would be inconsistent. In Manitoba language rights, temporary validity upheld until laws were translated into both English and French. Then in Scatcher case, temporary period of validity granted but preferred rectifying the statute by swearance and reading in. Then in Tetrod, severance used to remove the words age 65 for unemployment insurance benefit. So for the time being, you can stop something, but that does not mean that something you can exempt from constitution completely. So in summary, section 52(1) provide broad constitutionally grounded remedies for any inconsistency with the constitution, ensuring that all laws in Canada must align with constitutional principles, including those mentioned in Charter of Rights and Freedom. On the other hand, section 24(1) specify remedies for breach of charter tailored to address only individual rights violation. So first is reading in and swearance. This involves adding language to a statute to remedy a constitutional defect without striking the entire complete law. So whatever is missing, you can just add in that provision. This means reading in. Swearance means whatever part is unconstitutional, just take away that part and leave the remainder intact. So the case is Sketcher that we already discussed, then reading down, choosing an interpretation that avoids conflict with charter. So whatever charter expects, just interpret that provision in that way. So this is to minimize the impact of successful charter challenge and to uphold judicial restraint. Constitutional exemption is applied, is allowed for the minimum time, for the lesser time, not for always. So it allows the court to uphold a generally valid law by exempting specific application that would violate the charter. Sometimes courts give government time to just change the application, exempting individual who observe a different Sabbath from law mandating Sunday closure. This is example. Then limitation, it is not applicable for minimum sentences deemed grossly disproportionate. Entire law must be struck down instead. So this happened in Ferguson case. Then sometimes the court, what they do, they can redraft common law rules like R versus Wine. But general rule is the courts cannot reconstruct statutes. So that is the job that has to be performed by a legislative body. But when it comes to common law, then sometimes courts redraft the reconstruct the rules. Limitation of action. When a statute is declared unconstitutional, it is considered so from its inception, from the very moment it had come into existence. So the effect of unconstitutionality goes retrospectively. Section 24(1) remedies. So these were the remedies that are as per Section 52. Now Section 24(1) remedies provide for breach of charter right. Only the person whose right were infringed can ask for this remedy. So Section 24(1) is not the only remedy. Section 52 also applies, rendering inconsistent laws void. This we know. Section 52(1) allows for broader standing than Section 24(1). So the remedies that we talked about here are broader ones. Section 24(1) applies only to existing right infringement, not the future potential one. Here we are providing something so that some government should learn from their action and cannot repeat such thing in future. So courts can order various remedies as long as they are appropriate and just. Legal position can be declared without additional order as held in Canada versus Khadar. Then usually under Section 21 we get damages and court. Then supervision orders, like supervision should be last resort as per Peter Hawke for governments failing constitutional duties, because here we are saying that court is interfering. Court is doing the job that the government has to do. So this is rarely followed. Usually we give damages and cost when it comes to Section 24(1). Then administrative tribunals can decide charter issue if they are empowered by statute. Without power, they cannot refuse to apply law based on unconstitutionality. Preliminary inquiry judges can decide constitutional question affecting the validity of charges, then admissibility of evidence, then ensuring proper proposed statutes and regulations comply with the charter. This is mandated by Department of Justice Act and this is the job of Minister of Justice. Enforcement of charter is primarily through courts as per Section 52 and 24. These constitutional remedies ensure that statute complied with charter while providing various tools for court to address constitutional defects in legislation. Now, what is Section 24(2)? Exclusion of evidence. So, most common remedy of rights is exclusion of remedies. Whenever your right is being infringed and some evidence was taken under that thing, so that evidence will also be excluded, that evidence will also be held unconstitutional. So causal connection is not necessary here, just need the breach of the charter right to be temporarily connected to collect the evidence that there was a breach of charter right and with that breach some evidence was collected. So the evidence here in itself will be excluded. Burden is on the claimant to prove the test. Standard is normally easy to prove. Two main questions for Section 24(2). Was the evidence obtained in a matter that infringed the charter right? If yes, would admitting that evidence bring administration of justice into disrepute? So cannot be used to admit evidence that would be inadmissible by law. Test cannot be used to establish admissibility of evidence that evidence for other reason. Section 24(2) is used in criminal proceeding. The most common remedy for violation of right is the exclusion of evidence. So this is the most common remedy. So you have to keep this in mind. Evidence that is obtained in a manner that infringes a charter has definitely to be excluded until and until it is justified. A causal connection between charter breach and the evidence obtained is not necessary. We already talked about this thing. Then three elements that has to be certified. The person claiming the breach must have standing. You must show that there is a connection between evidence and charter breach. You must show that the admission of evidence will bring administration of justice into disrepute. So these are the three considerations that came out in R versus Grant. The seriousness of charter infringement, state conduct, more serious, more likely it will be excluded. This is important line. If it was in good faith, evidence may still be admitted. Impact of breach on charter. The more breach impact claimant, the more likely the evidence will be excluded. Society's interest in the adjudication of. So the court will look at the reliability and importance of the evidence and seriousness of the crime. The more public interest in the evidence being admitted, the more likely courts will allow the evidence. So now we are going to talk about two cases. So in notes, I have mentioned few additional cases as well. If you want, you can follow those. But these two cases are the ones that are mentioned in syllabus and you cannot miss on these. So first is Brent versus Alberta 1998. So paragraph 129 to 179, what were the facts? Teacher was dismissed from his job for being homosexual. Supreme Court of Canada found that Alberta's human rights legislation violated section 15 of Charter by not offering a remedy for discrimination based on sexual orientation. So see, this is the thing from where the analogous ground of sexual orientation section 15 discrimination comes up. Legislation did provide remedy for discrimination on other grounds, the enumerated ground, but not on this analogous ground. So what judge says, legislatures conferred upon the court the grant to power to grant remedy under section 24 and 52. There existed dialogue between different branches of government holding each other accountable. So what are the guiding principles? So courts are guided by values essential to a free and democratic society, including respect for dignity, commitment to social justice, equality, accommodation of diverse belief, respect for cultural and group identity, faith in social and political institutions. So what is the remedy in this particular case? So the case leading on remedies is Catcher versus Canada. Firstly, define the charter inconsistency. The exclusion was based on sexual orientation, then decide appropriate remedy. While some suggest reading in sexual orientation, the court found appropriate remedy was to declare provision unconstitutional and suspend that declaration to allow the legislature to address the matter. So Sketcher case emphasizing respecting the role of legislature and purpose of charter. Hunt J.A. concluded there was insufficient precision to justify the remedy of reading in. Reading in is appropriate when under inclusive legislation voids the charter. Code section does not intend the legislative process. The legislature can respond with new legislation. Legislatures can always invoke section 33 of charter. So what was the conclusion? Reading in sexual orientation as a protected ground. So here the remedy was reading in, most suitable remedy for this under inclusive legislation. Then next was Vancouver City versus Ward. Ward was mistaken for a person planning to throw a pie at Prime Minister. He was chased, handcuffed, arrested for breach. The trial judge awarded damages $100 for car seizure, $5,000 for strip search. The Court of Appeal upheld trial judge decision. Issue was, were these remedies provided to this person were appropriate? So appeal was allowed in part. Damages for strip search was appropriate. No damages should have been assessed for the impounded car. What were the reasoning? So firstly, establish if charter right was violated, definitely. Show why damages were a just and appropriate remedy. So consider the function of compensation, vindication of right, deterrence of future breaches. Then functional damage, justification for damages. State can argue against the award of damages if countervailing factor exists. So if the state fails, assess the quantum of damages. So here strip search violated Ward's section 8 charter right. So damages are justified to fulfill this objective of constitutional damages. But no countervailing factors were established. So judge award of $5,000 was appropriate given the seriousness of injury, non-malicious nature of officer's action. Then about car seizure. Ward did not suffer injury from the car seizure. The objective of vindicating the right and deterring future breaches were not compelling in this context. While wrong, the seizure was not of a serious nature, so making damages inappropriate from a functional perspective. So damages for this strip search were justified, were valid. That were 5,000. So that was all about today's lecture. At last, in the upcoming lecture, we will be talking about answer writing things.